Hello, this is Matt on the Moon Lambeau channel. Attorney John Deaton has pointed out that Bitcoin is what drives the price of XRP, not Ripple. This could not be more obviously true, despite the SEC making an argument to the contrary. Also, the Chamber of Digital Commerce is finally going to be jumping into the SEC versus Ripple case. It's been endlessly frustrating that XRP holders have been getting almost no support from the crypto community at large, despite the fact that what happens in the SEC versus Ripple case is going to impact the entire asset class. So even those people that despise XRP and presumably they're remaining silent because they don't like XRP specifically and or Ripple, this is going to impact them. Well, finally, I've got a quick update on the Chamber of Digital Commerce and how they're going to be moving forward. We don't have a ton of specifics yet, but I want to share with you what I learned. And also, I want to share with you what an attorney within the XRP community has pointed out regarding an aspect of the SEC versus library case, and how the SEC is making, well, frankly, they're making a similar argument in the SEC versus Ripple case, so you can see this kind of tactic, but it couldn't be more clear that they are just not in line with decades of set precedent from a legal perspective. And so I want to share with you that thought process as well. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so here's a tweet from just this afternoon from attorney John Deaton, and he said the following. Expert reports have been submitted and depositions completed, but the last few weeks have totally proven XRP's price is not driven by Ripple, but by Bitcoin. Brad Garlinghouse announced on-demand liquidity increased 6 to 8x, and Ripple is hiring while others are laying off. Yet XRP's price ... Exactly. And this is a point that I've brought up a number of times over the last year and a half. But given how pronounced the drop in crypto asset class globally has been and how it's all pretty well been in tandem, this paints a picture that could not be more clear. As all of the underlying business metrics for Ripple as a private held company, while all of that gets better, the price of XRP has gone down precipitously in line with the rest of crypto markets, having nothing to do with Ripple. Now, this all despite the fact that they hired a Dr. Albert Metz as an expert witness, getting paid $600 an hour to write a 100-plus page report. How many tens of thousands of dollars do you think he got paid? So a 100-plus page report to allegedly prove that XRP, the price really moves based on what's happening with Ripple. Well, good luck arguing that, especially with this precipitous drop. Good luck arguing that now, because it could not be more of a bold-faced lie. Like, I don't even think that this guy, because it's so absurd, I don't even think that this guy is incompetent. I think he made a report that he can't believe because it's that out of tune with reality. I don't know how a person could actually believe this. And mind you, so Ripple's got their expert witnesses too, and they've rebutted it. And Dr. Metz still, there's that monetary incentive. I can only assume that's the reason why. What other reason is there to do this for the SEC? But it truly, truly is that far out of line with reality. I don't know what else I can suppose. And I admit I can't know what's in the heart and mind of this guy. But what is one to think when you're that out of tune with reality? Because it's pretty damn extreme here. But and it is true. So it's actually about an 800-fold increase in on-demand liquidity year over year. That was a story which was making headlines at the beginning of May just this year. 800% increase in on-demand liquidity, which requires the usage of XRP. Yet the price of XRP goes down despite all of this positive news. So look, as much as I don't like seeing the price of XRP go down, if anything, it will help the SEC's case. And this is of crucial importance because it goes back to this idea, and it's a prong of the Howey test. Is there a common enterprise? If yes, then one of four prongs is satisfied. But this is proof that there is not a common enterprise. Think about this. Okay, and then there was this. Look at this headline. This comes from Blockworks, but this has been talked about widely today. The headline from Blockworks is as follows. ProShares to launch first U.S. ETF that's bearish on Bitcoin. Yes, indeed, folks. It's an ETF, which is betting against Bitcoin. And John Deaton had something to say about this, which is why I wanted to share with you just a little piece of this. It's interesting. And mind you, we still don't have a Bitcoin spot ETF. Jay Clayton wouldn't approve it. And well, he was against it until he left his leadership role at the SEC. Now he's for it. He actually joined a firm which actually applied for a spot Bitcoin ETF, and then Gary Gensler's now in charge. Gary Gensler denied that, actually, funnily enough. I recently reported on that. But Gary Gensler's against there being spot Bitcoin ETFs too. Why might that be? Anyway, so it reads as follows. Looking to profit from an extended downturn in cryptocurrency markets, an ETF that bets against Bitcoin is set to start trading Tuesday in the United States. Run by fund issuer ProShares, the Short Bitcoin Strategy ETF is designed to deliver the inverse of the performance of the S&P CME Bitcoin Futures Index via bearish Bitcoin futures. The company is dubbing it the first short Bitcoin ETF in the United States. The company is also set to launch a mutual fund, the Short Bitcoin Strategy Pro Fund. Neither fund will invest in Bitcoin or other cryptocurrencies directly. Now, let me just pause to note here. When it comes to a spot Bitcoin ETF, which is an exchange-traded fund that is backed by actual Bitcoin, which means it's impacting supply and demand, which means it's arguably more important than just having a Bitcoin futures, which were approved in late 2017. The SEC, if there's ever going to be a spot Bitcoin ETF, the SEC must approve it. That's just the way it works. Now, given that this is an ETF, I don't know for sure if there are exceptions to that, or if this is a particular type, since it's betting against, as it's cited here, the Bitcoin futures index, so via bearish Bitcoin futures. I don't know for sure if the SEC had to approve this, but I swear to goddamn, if the SEC approved this and they won't approve a spot Bitcoin ETF, it's just like endless quantities of eggplant emojis for these individuals. Like all of them, I'm going to give an eggplant emoji to every individual SEC employee. Because what else do you do in a situation like this? So I don't know for sure if they had to approve it. I couldn't find information on that. But we know they're against the Bitcoin spot ETF. And so here was a tweet from Will Clemente, who does all sorts of on-chain analytics for Bitcoin. And so from time to time, I'll highlight stuff he has to say on videos where I'm typically more so talking about price. So you may be familiar with the guy's name, but he tweeted out the following just this afternoon. He said, so there's now a short Bitcoin ETF, a futures ETF, a closed-end fund trading at a 30% plus discount, a 401k option for Bitcoin, but no spot ETF. No kidding. It's ridiculous. He says, it is clear that Gary Gensler and the SEC have an agenda against Bitcoin. Right? Well, that's how it struck me. And here's what Attorney John Deaton had to say about this. It is absolutely outrageous that Gary Gensler and the SEC allow the institutional incumbents have a derivatives Bitcoin ETF and a short Bitcoin ETF while not allowing a spot Bitcoin ETF. Why the industry doesn't get together and coordinate lawsuits against the SEC is beyond me. Yeah, wouldn't it be nice if there was some coordination on that front? But we're not really seeing a lot of rallying of the troops, certainly in the SEC versus Ripple case, that's for sure, in terms of major entities out there speaking up on behalf of XRP holders. Which is a perfect segue here. I'll jump to this. I was going to cover this last, but this is a better segue. So let's just talk about this briefly here. So the Chamber of Digital Commerce was founded by Perry Ann Boring. It's the woman here where I'm circling on your screen. And she does strike me as a rather sharp individual. She had already publicly stated that they were going to jump in some capacity into the SEC versus Ripple case, but a little bit short on the details on that. Well, she ended up being, just within the last few days or so, interviewed on the Thinking Crypto YouTube channel, and she was asked specifically about SEC versus Ripple, and she said yes, what they're going to do, and they are jumping in, they're going to be filing an amicus brief in the SEC versus Ripple case. And so amicus briefs, this is key, and this is what Attorney John Deaton ultimately did too. He filed an amicus brief. Well, so again, Perry Ann Boring with the Chamber of Digital Commerce, she says their organization will file an amicus brief, and amicus briefs show the court that their final decision will impact people other than the parties involved, other than just the parties involved. So obviously there's the SEC plaintiff and then the defendant Ripple. It's not just about them. It's going to have global impacts. That's not too much to say that. I understand that when you're talking about securities laws in the United States, but there will be ripple effects, pun not intended, throughout the entire world as a result of this. There really will be. And the Chamber of Digital Commerce seems to understand this. Now, I am kind of wondering why it's taking them so long to jump in, but still, better late than never. I appreciate the support. The amicus brief has not yet been filed, but I really look forward to seeing what's in there. And she did make clear in the interview, she said, so look, we're not taking the side of the plaintiff or the defendant. But don't be turned off by that. Like, that's the point. If you're filing an amicus brief, you're a third party, right? You're maybe your interests don't align. That's the point. That's the reason that the court should pay attention to you, right? And given that XRP is decentralized, that seems like the right approach, and I think that's obviously why Attorney John Deaton took the approach that he did as well. So this is positive news. It's regretful that we haven't seen really pretty much any activity from third parties outside of this. I mean, it's great what Empower Oversight's been doing, but really pretty much outside of that, it's just been crickets, right? And so Chamber of Digital Commerce Twitter account, linked to that video on the Thinking Crypto YouTube channel, and then John Deaton said the following about this. Said, Perianne Boring explains that the Digital Chamber of Commerce plans on submitting an amicus brief in the SEC versus Ripple case. Great news. Yeah, and so it is great news. I'm looking forward to seeing that, and it's just going to make it that much more clear to the judge. Because think about this. It's just Ripple, right? Controlling XRP, right? And it's clearly a security. Well, the more parties that jump in and say, actually, no, there are parties outside of Ripple that have different interests for different reasons. The more parties that do that, the more clear it is to the judge that the SEC is way, way, way off base in their legal arguments. Way off base. And they clearly are. Logic be damned, they just make stuff and they hope that it sounds sufficiently intelligent to the judge and they can just get things past the judges, but it really hasn't been working very well in the pretrial hearings. Let's just say that, right? And then there was also this, and this is interesting. Attorney John Deaton had something to say, but there's a short thread from an attorney named Bill within the XRP community, and he's talking about some developments within the SEC versus Library case. So check this out. He wrote the following. One interesting point Library makes in its opposition to the SEC's summary judgment motion is that the Howey test is transaction specific, and the SEC has recognized this to be so. So let's pause to note what he's saying there is that if you're going to claim that something falls under Howey, like it's something satisfies the Howey test, meaning that it is indeed a security, if you're going to claim that, then there needs to be specific transactions that are cited. That's how this works. And so again, Attorney Bill here is stating that the SEC has acknowledged this. That's what's being pointed out by Library in this case. They're saying, hey, yes, the SEC has stated this in the past. And you can see, here, I'll just pull this up full screen for a second. There's a screen grab here. So this is from Library, their legal team put this together and said, as both the Supreme Court and the Commission itself has recognized, the Howey test is transaction specific, and the determination that an instrument is a security at one point in time does not dictate that the instrument will constitute a security for all eternity if circumstances surrounding the offer or sale of the instrument change. Exactly. And by the way, former SEC chair and asshat Jay Clayton, he said as much. And I've highlighted that before. He gave a speech at some university, and he's talking about he gave an example if there was a library token, and if it was raised to create it, or is it actually a functional token which can be used at the laundromat? It was something to that effect. And the reason he was stating that is to point out that the circumstances matter and things can change. That could not be more clear here, and that's what Bill is getting at. And then he continues. They cite Hinman's Ethereum free pass speech in support of that argument. Nice touch. Despite the fact that the SEC knows this, they now recently told the court that SEC attorneys gave Hinman legal advice to ensure his speech was consistent with the SEC's understanding of the application of the Howey test to digital assets. They argue in the Ripple case that XRP, even in the secondary markets, is a security, and that Ripple has made one continuous offering of XRP, apparently not transaction specific, ding, 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 for years and still ongoing. You can't make this stuff up. So think about this. They have acknowledged publicly, and it's been true for decades on end, that if something's a security, it's transaction specific. Yet here, in the SEC arguing against Ripple, they're not arguing against specific transactions. They say every transaction, even in secondary markets, is one continuous securities offering. That is not transaction specific. That is not how the law works, but that's what they're arguing. These people are tremendous asshats. It's really grinding my gears, folks. Attorney Bill continues. Here's a specific example of library objecting to the SEC's attempt to characterize specific offerings or sales of LBC, that's their cryptocurrency, the LBC token, as a continuous offering and drawing attention to the separate transactions. The SEC needs to argue a single continuous offering both to support its assertion that cryptos are securities per se and to try to convince the court that there is a common enterprise that extends to secondary markets and all investors. End of thread. So it highlights perfectly the degree to which this is an attempt at a power grab. It's way beyond overreach. Overreach is a euphemism at this point. No, it's way beyond overreach. I mean, the second, think of it, I could send you 5 XRP, and that represents a securities transaction? To what end? It's a disgusting argument, and it wrecks open and free markets. It really does. Here's what Attorney John Deaton had to say about this. This is why I filed the writ versus SEC. The SEC is supposed to claim a specific transaction on a specific day equaled an offer and sale of a security. Instead, it alleged every sale from the beginning until today is a security. That was the second indication the lawsuit was a weapon. Exactly. Ding, 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 hitting the nail on the freaking head. I am so thankful we have John Deaton actually pushing back and fighting against this. He's one of the voices that has been just going at it nonstop from the earliest of days. Or we don't get support from the broader crypto community. Like, I'm talking people running organizations that purport to speak on behalf of the betterment of the entire crypto asset class. You just get crickets. So we're lucky to have John. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.